Hello everyone, welcome to my YouTube channel. In this video, I just want to define the Prevention of Money Laundering Act in totality. There are total 10 chapters in PMLA, total section 75. There is one schedule, and before starting PMLA, I just want to make it clear that there are certain chapters which are very important for the every exam point of view, especially the exam recently going to held on 11th of January 2026 by UPSC with regard to the post of CBI APP, CBI APP, etc. So this video I will cover the whole Prevention of Money Laundering Act. If this I'm going to make this video in a totality with regard to the important sections for the exam point of view. I have already made one video which is already uploaded in my YouTube channel. You can refer this video also and that video also. That is about history of PMLA, why we made this act. This you can refer that video which is already in my YouTube channel. It is a second video of Prevention of Money Laundering Act. So we have already know about the Money Laundering Act, which is a prevalent act right now. We have seen that in many states ED has making an investigation with regard to the proceeds of crime or with regard to the scheduled offences when the property is they have attached the property. So there are certain chapters. We have already know that there are 10 chapters under PMLA. There are 75 sections. There is one schedule. So firstly we have to complete chapter number 5. Under chapter number 5 there are section 16 to 24 which are very important with regard to section 19 and section 24. It is the most important part of PMLA. 19 is talk about the arrest and 24 talk about the burden of proof. There are a lot of judgments came recently delivered by the Supreme Court and different high courts which are very important to understand the concept of PMLA. Before starting PMLA, we have to understand what is a schedule offense, what is a schedule offense, and what is a proceeds of crime. Before starting PMLA, we have to understand these two definitions. Schedule offense is covered under 2 clause 1 clause Y. All the definitions are important, especially the schedule offense covered under 2(1)Y, which says the offense covered under schedule. The offense covered under schedule. If you go through schedule, there are three parts. Part A, Part B, Part C. Part A having 29 acts. It covered 29 acts. Paragraph 29. Total 29 paragraphs are covered under Part A. It means that it has mentioned 29 acts. If any offense a person has committed under different 29 acts and resulting some property he have acquired through such illegal activities, that property may be considered as a property for a PMLA. So you cannot acquire that property if you are committing any schedule offense which is covered under Part A, Part B, Part C. Part B is talk about the Custom Act, section 132. Part C is talk about the cross-border offenses covered under A and B part. So whenever, let's suppose you have committed a NDPS offense, some recovery was affected from you, like the puppy is recovered from you. So puppy is having a value about 10 lakh. I'm just giving the example. And one cash is also recovered from you. Some property is also recovered from you, and it is says that you have acquired that property by selling that poppy to somebody. So you have acquired that property illegally. That cash you have acquired illegally. That cash, that property is a property for PMLA to initiate the proceeding under PMLA. So under NDPS, one FIR may be registered against you. That FIR give power to ED under PMLA to initiate a investigation for the purpose of PMLA. There is a one section 3, which says definition. It defines the word money laundering. Money laundering is what is money laundering? It is also talked about section 2(1) clause P. What is money laundering? Money laundering general meaning, if a layman meaning, if we understand a layman meaning, then it means that when a person having a black money, he just want to make it a black, he just want to make it a white money. So we have to cut that line, prevent that line. That is called a Prevention of Money Laundering Act. So that black money is considered as a money laundering, which is acquired by illegal activities, defined under 2(1) and section 3, and offense is section 4. Always there is only one offense which is generally attracted against accused, which is section 4, having a punishment 3 years to 7 years. But if the schedule offense, which is a person has committed under NDPS Act, let's suppose the poppy is recovered from him. In that case, if schedule offenses of NDPS Act, then the punishment may be increased from 3 years to 7 years to 3 years to 10 years. 3 years to 10 years, which is covered under section 4. So there are many types of authorities given under this act. Proceed of crime is it means the property, it is defined under section 2 clause 1 clause U. It says property directly or indirectly derived or obtained by the person as a result of criminal activity relating to schedule offense. So there must be a schedule offense, and whenever the property is acquired through schedule offense, that property is treated as a proceed of crime under this act. If there is a proceed of crime, then only the investigation may be initiated under PMLA. There are 4 types of authorities given under PMLA. First is section 48, the authorities of ED: director, assistant director, additional director, joint director, deputy director, or any other class of officer appointed for this purpose. It is given under section 48. And when you call about a director, additional director, and joint director, it is already defined under section 2(1)K. So this definition is important. When you says about a deputy director, it is defined under section 2(1)J. When you talk about assistant director, it is defined under 2(1)C, the assistant director of ED, which is these authorities are covered under section 48, appointed under section 49, but defined under 2(1)K, 2(1)J, 2(1)C. So you have to understand this concept while doing 48. You have to complete it 49 and 2(1)K, 2(1)J, 2(1)C. Thereafter, the ED having a authority under section 5 to attach the property. They always attach property under section 5. And second authority is given under section 6, which is adjudicating authority. Adjudicating authority. And which is defined under section 2 clause 1 clause A. And whenever that authority is adjudicating whether this property which is already been acquired by ED or seized by the ED under section 5, this authority adjudicating this under section 8, whether this property has to be, which is already be seized by the ED, has to be retain seizing, which is section 8. Adjudicating authority making that inquiry under section 8. Section 25 is saying that whenever any authority, that is appellant authority, 25 is talks about appellant authority. Appellant authorities feel like the authority under CPC, civil court, act like a civil court. Whenever adjudicating authority decide whether property attached or seized is involved in a money laundering, then the appellant authority hear the appeals. Hear the appeal against adjudicating authority or any other authority. 45 days have a mentioned period on which the person may file appeal or ED may file appeal if the appellant authority find that this is not a fit case to seize that property, because this property is not a property of a proceeds of crime. Appellant authority, section 25, which is also defined under section 2 clause 1 clause B. 2 clause 1 clause B. And fourth authority is covered under section 43, which says a special court. Special court is always a court of session. Central government designate any any court of session as a special court, and judge may be appointed by the central government with the consultation of a concerned chief justice of concerned high court. That is the way you can understand. These are the 4 sections which talks about the 4 types of authority. Section 48, 6, section 25, 43. So firstly, the question may come in your mind that how the proceeding of ED may be initiated. Whether the FIR is mandatory? Yes, FIR is mandatory, or charge sheet is mandatory. Charge sheet or complaint. Complaint by the person who have a power to investigate the matter under PMLA. So ED always see whether the FIR of a scheduled offence is there, whether there is a charge sheet against a person with regard to scheduled offence, and there are reason to believe that there must be some proceeds of crime, and then ED may initiate the proceedings. Or there is one complaint against that person with regard to the some kind of scheduled offence, and now ED is making mind that have a reasonable belief in writing that there must be some kind of proceeds of crime. So why not the investigation to be conducted? These are the way the ED always make a investigation without FIR, without any charge sheet, without any complaint. They cannot initiate any proceedings. But since there is a one case law which says otherwise, Vijay Madan Lal Chaudhary versus Union of India. It is a 2022 Supreme Court case. It says that whenever a private complainant came before AD, private complaint for file a complaint to ED that there are certain property which is considered as a proceeds of crime, that some corruption has made by that person and he acquired that property, and that property may be considered as a proceed of crime because that person is trying that black money changes into white money. That is why it is considered as a proceed of crime. Then ED may temporarily manner may attach that property. from temporary manner for certain time, and temporary manner is given under section 5, that is 180 days, longest 180 days. And in the meantime, when they have attached that property, they must within 30 days of such attachment file a application before adjudicating authority to decide whether this property should be retained for further attachment or not. And whenever he has attached that property under section 5, instantly, immediately, he has to inform the adjudicating authority that we have attached that property. And within 30 days, they have also filed a retention application that this property is, we have already informed you about this attachment. Now this attachment has to be retained further. And now adjudicating authority have a power to retain till 1 year, 365 days, or 365 days, or 1 minute, days, or we can say that authority which they are exercising, adjudicating authority can retain that property for 365 days, and further this power is given to special court. Special court will take consideration whether the ED which they have acquired property or which they attach that property, whether it is a proceed of crime, they start a trial of that offense. If in the meantime, if I've already said that there must be some schedule offense, if in a schedule offense there may have that accused got acquittal, then the special court must finish the trial of that PMLA proceedings. PMLA proceeding cannot be initiated if the schedule offense, in a schedule offense, person got a acquittal or discharge. So the property must release to the concerned person, because there is no schedule offense. If there is no schedule offense, there is no proceed of a crime. So generally, which the temporarily manner on a base of private complaint, it is for time being only. So adjudicating authority generally cannot attach that property if there is a private complaint only. It has to be released to the concerned person if there is only private complaint, because adjudicating authority has to wait whether there is a complaint against schedule offense with regard to that property, whether it may be considered as a proceed of crime for the purpose of schedule offense, which is expecting some FIR or filing of any charge sheet or having a complaint in any court with regard to that schedule offense. If there is no, then adjudicating authority has to release that property to the concerned person. So ED may initiate attachment proceeding on a temporarily basis, on a basis of private complaint filed against them, but adjudicating authority cannot do so. Adjudicating authority has to wait for some time whether that private complaint made before ED, on the basis of that temporarily attachment has been made by ED, whether to make whether that private complaint changes into FIR in every police station. Adjudicating authority has to wait for that for some time. If it is not, whether there is charge sheet with regard to that schedule offense, no. Whether there is a complaint with regard to that schedule offense, no. Then adjudicating authority has to release that property to the concerned person. No proceeding, no further proceedings. So there are many judgments under this act. The object of PMLA is very we can say that uh, very important. It prevent and control money laundering, confiscate and seizing the property obtained from schedule offence, or connected matters, if any, has to be deal with the PMLA. So we have already understand what is a schedule offence, what is proceeds of crime, types of authority covered under PMLA. So we now section 12 is very important, which says 12 and section 11A, very important, that is a reporting authority. Banking authorities are considered as a reporting authority. Financial institutions are considered as a reporting authority. Whenever any person using a banking transactions or banking or we can say that if any person sending some money to other person or taking some money from other person in a foreign country or within a state or within certain class of within certain areas, then banking institution always take a eye on such transaction. If there is a suspicious transaction that the person cannot make at that time, then they give such assistance to the ED regarding such a suspicious transaction. If ED find that there are certain proceeds of crime and for investigation they need the whole we can say whole network, they need to find the whole network, they can ask the reporting authority with regard to that account of that person to be given detail of such. So reporting authority is also important, given under section 12 and 11A, which is very important sections. Thereafter, in chapter 5, I have already disclosed there are certain sections which are important. Section first is section 16, which says about survey, power of survey. Power of survey is given to ED. They can enter any place if they find that offense under section 3 is committed by any person. They can inspect the record or check, verify the proceed of crime. Where a property or a record kept by the person, they make inspection of that record, inspection of that property. They can require any person, employee of that person to give such record so as to verify whether it is a proceed of crime or not. After survey, they have immediately report to the adjudicating authority. Immediately, adjudicating authority in a sealed envelope, and within 30 days they must file a copy of the reason with regard to the such seizure. If they have seized the record or seized the property because they find that the person has committed offense under section 3, which is defined under section 3, now they have immediately informed the adjudicating authority with regard to such seizure, and within 30 days they have to make an application to retain that seizure for further 365 days. So adjudicating authority can retain that seizure for 365 days, but the ED can retain it for 180 days. And 180 days is not exclusive that they have to take that property within their possession for 180 days? It is because the adjudicating authority has not decided yet, or the adjudicating authority having other applications pending and they could not take application, or application is pending for receiving that property, for making adjudication of that application. That is why 180 days is given. Otherwise, it is upon adjudicating authority to retain that property for purpose of special court, and it is always authority of a special court who can decide whether it is a proceed of crime or not after making a trial of that offence. And its trial is also dependent upon schedule offence, which is covered under schedule. If the person has got acquittal in a schedule offence, then the special court cannot do anything. They have to give order of acquittal of that case and release the property. Otherwise, if the person got the conviction under schedule offence, then special court can convict the accused and confiscate that property for the central government. That is the way the whole proceeding has to be done. Section 16 says that ED have a power to enter any place, power of survey. Section 17 says power of search and seizure. They can search and seizure. So without making search, without making survey, there is one provision which is to be complied by the ED. That is reason to believe must be in written form. Written form. They must said information, said secret information, said making of mind in a writing form. If there is no writing form, then it may not be considered as a good investigation or good inquiry. Thereafter, they can also search a person under section 18. For searching a person under section 18, they having a same way of investigation as covered under section 50 of NDPS Act. That is a personal search. If they want to conduct a personal search under section 18 of PMLA, that authority must copy of reason and material possessed report to the adjudicating authority within 24 hours or immediate manner. So ED want to make a personal search of the accused or personal search of the person. They have to took that accused to before a gazetted officer. Firstly, they have to disclose about his right that if you want to make a personal search in front of a gazetted officer, then you have a right. If that person want that search to be made before a gazetted officer, then ED must took within 24 hours before a gazetted officer. And before gazetted officer, that search has to be made. And two or more person shall be called by that authority in presence of that public person, that personal search to be completed. And female can be searched by the female only. And after doing these proceeding under section 18, that personal search has conducted, immediate copy of reason and material possessed by the person in a sealed envelope must send it to the adjudicating authority, and within 30 days application before adjudicating authority for retention of that record. Thereafter, section 19 talks about arrest, power of arrest to the ED. There is one judgment on section 19, Pankaj Bansal versus Union of India, 2023 Supreme Court, which says the written ground of arrest must be given to the person whom you want to arrest. If there is no written ground of arrest is given to the accused person, then that person may get a bail on the basis of illegal arrest. There is one other judgment on it, that is the Tarsem versus ED. Tarsem versus ED, 2024 Supreme Court, which says if, let's suppose, special court had already taken a cognizance, special court already take a cognizance with regard to money laundering offense against accused. Now ED cannot arrest that accused. Now ED does not have a power to arrest that person because against whom the summon has already been issued by the special court, cognizance has already been taken by the special court. Now no power to ED to make arrest of that person. It is delivered by this, it says by the in the judgment Tarsem versus ED. Thereafter Arvind Kejriwal is also one judgment, Kejriwal versus ED, 2024 Supreme Court. It says before making an arrest of the person under PMLA, that authority must satisfy the necessity of arrest. Why arrest is necessary? Must satisfy. It is not a routine manner you can arrest any person. And after arresting, ground of arrest has to be given in a writing, Pankaj Bansal says. Thereafter, immediate report to the adjudicating authority in a sealed envelope regarding the such arrest. And within 24 or production must be before a special court or a judicial magistrate first class having a jurisdiction. And if the person is arrested in somewhere else, that let's suppose the offense has committed in a Punjab and the person has arrested in a Delhi. So if the ED want to take that person in a special court in a Punjab, they have to firstly get a transit remand from a Delhi court, CGM court or special court in Delhi with regard to the said offense or session court. After getting a transit remand, they can shift that accused in a Delhi court and make a production before a special court in a Punjab. That may be the procedure which must you have heard about that. Section 20 and section 21, it is a talk about retention. Retention of property. Order of officer authorized by the director etc. may have authority to retain that file a application before adjudicating authority. And the same procedure which is given under section 16, 17 or 18, 19, it is given under section 18, section 20 and 21, the same order. So firstly, ED attach the property under section 5. Thereafter, they file application within 30 days before adjudicating authority, and adjudicating authority adjudicating the matter under section 8, whether to retain the property or release the property. They can retain the property, or before making attachment, ED may enter any place under section 16, seize property under 17, search and seizure 17, search a person 18, arrest a person 19. There is a presumption with regard to this section 22, which says presumption as a record on property in certain cases that it is a proceed of crime. There is a presumption under section 22. And if adjudicating authority, ED can attach property for the purpose of it for 180 days, longest 180 days. Now, the adjudicating authority can for 365 days or till the time special court not decided. If special court decided, release the property or confiscate property for central government. That is all about this proceeding is to be conducted under PMLA. Very, I may say that very easy. You have heard ECIR. It is not a statutory, we can say statutory kind of report. It is a enforcement case information report. It is a one kind of a document for administrative purpose. It cannot be mandatory on a part of ED to show that report to the accused. They can make secret that document within their self and started making a investigation. There is one other section, section 50 is important, which says on oath examination of a person, and ED has a power of a civil court, and whenever the ED record the statement of any person, it is not considered as a inadmissible. It is always admissible, because ED officers are not considered as a police officer. So the statement recorded by the ED under section 50 is admissible under Indian Evidence Act. That is defined, that is delivered, that is a part of the judgment delivered by the Vijay Madan Lal Chaudhary versus ED by the Supreme Court. So section 24 is very important. Section 45 is also very important. In section 45 there are lot of judgments, we can say, and first judgment was Nakesh Tarachand versus Union of India and others, 2017 Supreme Court. It says that the twin condition covered under 45, twin condition given under section 45 is declared is a violative of article 14 and 21, so declare unconstitutional. So 45, the twin condition under 45 declared unconstitutional. That the twin condition is already been NDPS. It is the same given under NDPS Act. So arbitrary classification and applied stringent bail condition only to offence under part A of schedule punishable more than 3 years, rather than offence of money laundering itself, cannot be treated as a good classification. It is an arbitrary classification. And a reversal of a burden of proof also criticized by the court. And presumption of innocence, Supreme Court says that the presumption of innocence is a fundamental right that cannot be casually displaced unless compelling state interest. So section 45 is declared unconstitutional. Thereafter, the amendment was made in the year 2018 so as to nullify this judgment. Certain words are added. Again, the then twin condition is added. That twin condition is again challenged in Vijay Madan Lal Chaudhary versus Union of India or ED, 2025 to 2022 Supreme Court. It says for section 45 is a constitutionally valid, twin condition is valid. Even a bail stage, reversal of burden of proof on accused under section 24. has to be there. So section 24 is also declared constitutional. Section 19 is also declared constitutional. Section 5 is also declared constitutional in this judgment. Vijay Madan Lal Chaudhary versus Union of India. These three sections declared constitutional. It is also says that ECIR, I have already mentioned this, that the copy of ECIR disclosed to accused is not mandatory because it is an internal document. It is a only internal administrative document. And section in this judgment, Supreme Court also held that section 50 is the statement recorded under section 50 is also admissible. In this judgment, Honorable Supreme Court said. So this is the crux of Vijay Madan Lal Chaudhary. The review is pending before Supreme Court in 2025. Now, in 2025, in the month of March or month of April, the proceeding of review may be taken place. Till the time, the Vijay Madan Lal Chaudhary versus Union of India is a fundamental law of PMLA. There are many judgments on section 24 as well. Because if you go through section 24, there are amendments for section 24. Section 24, when it was made under 2002, the word accused was mentioned in this section. But in 2013, the word accused is omitted. The word person charged is used as per the guidelines of FATF convention, which says you cannot classify a person as accused unless and until there are certain material against him. That is why the person charged is to be used. So section 24 talk about burden of proof. It says prosecution does not have a burden. Prosecution does not have a burden to prove his case. It is upon the accused to disprove this burden. Reverse burden upon accused. So there are many judgments on it. The firstly, Vijay Madan Lal Chaudhary versus Union of India 2022 Supreme Court said the ED must, without kicking section 24 into effect, ED must prove foundational fact. Foundational fact. There are three foundational facts which has to be proved by ED, even at the bail stage, even at the trial stage, for proving this offense. When a person is charged under ED, under PMLA, and that person want to file a bail application, at that time there is a certain section 2045 says there is a twin condition. If that twin condition is not met by the accused, he cannot get a bail. But before coming into 45, we have to go through section 24. That is, ED must prove foundational fact even at the stage of bail. And what is a foundational fact? First foundational fact is that there is a commission of a schedule offense. My lord, there is a schedule offense. Some FIR, copy of FIR, some charge sheet, some kind of a complaint has to be filed by the ED before the court. Existence of proceed of crime. There are existence of a proceed of crime. Proceed of crime. That a property possessed by the accused having a link with illegal activity. That has to be shown by the ED. And third, there is a direct or indirect involvement, my lord. Direct or indirect involvement of accused by possessing that property, that property is a proceed of crime. That is because of a schedule offense. That is because of indirect or direct involvement of the accused in illegal activity. That has to be proved by the ED. If the ED has proved that fact during bail application, that then twin condition given under section 45 come into play. Now there is no bail. Very stringent condition. So at the trial stage, section 24 may come into play. At a bail, section 40 may come into play. So section 24 may play a role during bail as well as trial. But section 45 says only at the stage of bail. So trial stage or bail stage, 24 says there is a reverse burden. So ED has to prove the foundational facts, then section 24 comes into play. Then section 45 comes into play at the time of bail. But a trial, section 24 is always there. So there is a latest case law on it. One is Prem Prakash versus ED 2024 Supreme Court, which says generally the PMLA offense cannot survive alone. There must be some offense committed, a schedule offense, there must be trial going on, there is some conviction on it. Otherwise, the offense under PMLA will kick out if there is acquittal in a schedule offenses. So, firstly, 3 foundational facts has to be proven by ED during bail, and statement to ED during investigation is inadmissible. I am not talking about section 50, because in section 50 they have taken the oath of the person, but during investigation they have not taken the oath, it is inadmissible. And all the documents which are against the accused has to be given to the accused. It is a part of fair trial, this judgment says. Every document has to be given except ECIR, because it is an administrative document, need not to be given to the accused. So in section 24 there are 2 types of presumption. First is mandatory presumption. Second is A part is a mandatory presumption, B part is a discretionary presumption. So even at these are the judgments which generally say. So we have already seen the section 45 says having a twin condition. What are the twin conditions? We have to go through section 45, which says that section 45 says there is a twin condition which says that the public prosecutor has to given the opportunity to oppose the application, and court is satisfied, twin condition in that court is satisfied that person is not guilty. So you have to prove that you are not guilty at the stage of bail, or you are not likely to commit any offense, while on bail. So if you want to take a bail, you have to prove that I am not guilty, I am not likely to commit any offense while on bail. If that condition is not met by the accused, no bail. But since if the trial is to be conducted, a trial take of so many years, so there is no bail under PMLA. That is not. But there are certain case laws, Manish Sisodia versus ED 2024 Supreme Court says that prolonged incarceration, prolonged person putting in a jail, and a slow trial can override the strictness of section 45 PMLA. Bail may be granted to the accused. Section 45 cannot play a role if there is a prolonged delay of a trial and the person is kept in a jail for so long and trial is not concluded in a time bound manner. Bail may be granted even though there is a twin condition under section 45. So there are provisions under BNSS or CRPC. One of that provision is 436A, which is 479 BNSS, which says if half of punishment is already been done by the accused, now under 479 BNS, bail may be granted under even a PMLA, because it says that a long delay in a trial is a ground for taking a bail. Even though 45 is there, 45 cannot play a role on that conditions. There are other judgments as like Manish Sisodia versus ED. One is K. Kavita versus ED. It is also a judgment of 224 Supreme Court. One judgment is Uddhav Singh versus ED, 2025 Supreme Court. Other is Vijay Nair versus ED, 2024 Supreme Court. These are the judgments which says even though there is a twin condition under section 45, if the person is kept in a jail for so long and trial is not to be concluded within a time bound manner, the person get a bail. These are the provisions. So it is all about PMLA, very important act but very simple act. I have 2 videos now. This is the second video of PMLA. You can also see my first video on this subject, which is in a Hindi language. It is in a English language. You can also refer both the videos for concluding the PMLA. Thank you so much.